Well, thank you for watching this MEL Safety Institute employee training session. I'm your host, Jeff Coleman. And for the next few minutes, we'll be dealing with the subject of workplace discrimination and harassment. We think this is going to be helpful to you and your coworkers because the truth is that workplace discrimination and harassment are relevant topics for all of us, perhaps even more for you as a government employee or volunteer. You're a steward of the public trust with a responsibility to get this right. And though there's been progress in this area over the last few decades, things are far from perfect. We know this. Harassment still happens in many forms. A recent study found that 45% of respondents had witnessed sexual harassment of a coworker. Obviously, the problem is still widespread. But how broad? That's what this conversation is all about. This training is intended to educate all those involved with police and fire and roads and utilities, to housing, recreation, libraries, and citizen services within the local government. Both volunteers and employees are included under the protection of the law because harassment and discrimination constitute a direct violation of civil rights. There is no immunity in a harassment lawsuit. Everyone must know their rights and responsibilities to protect themselves and those they work with on a daily basis. So, discrimination, let's cover it here. The New Jersey law against discrimination goes back to 1945 and was the first of its kind in the country. This law was enacted to protect people from workplace discrimination based on race and age and sex and disability and sexual orientation and marital status and other factors. Under this law, it is illegal to discriminate in any employment action, including hiring, promotions, or terminations. We must be particularly vigilant to treat all people the same. So if you have questions, talk to the person in your organization who is responsible for personnel and human relations. It is also illegal to discriminate based on politics. The old adage, to the victor belongs the spoils, no longer applies. Public employees may not engage in political activity while on the job, and political affiliation may not be the basis for any employment action. Let me repeat this. No election politics in the workplace, and under no circumstances are you to use public property for anything involved in a political campaign. Now let's talk about sexual harassment. In recent years, we've also witnessed an increased awareness about sexual harassment. Now, while attitudes have changed for the better, a recent study by the New Jersey Division of Civil Rights reports that 81% of women and 43% of men have experienced some form of sexual harassment inside or outside of the workplace during their lifetime. This includes verbal, physical, cyber harassment, and sexual assault. 68% of women reported being sexually harassed in a public space and 31% at their residence. Sexual harassment affects people regardless of race, religion, or gender because it is fueled by power imbalances. Marginalized communities are uniquely vulnerable to sexual and other forms of harassment. Now get this, 45% of all harassment complaints every year are sex-based, and nearly 1/5 of the American adult workforce has been sexually harassed in the workplace. According to a recent report of the New Jersey Division on Civil Rights, there are 3 types of sexual harassment. Criminal sexual harassment involves coerced sex acts, physical confinement, intentional physical touching of a sexual nature. This activity is a felony, which could mean jail. Now, quid pro quo, that's harassment involving trading of favorable treatment for sexual favors. It's illegal for anyone to even suggest something of this nature. Quid pro quo is that Latin phrase meaning something in return. Now, the hostile environment is the 3rd type of sexual harassment. This would include making unwelcome sexual advances or offering offensive remarks or engaging in unwanted physical contact or creating an intimidating hostile environment by such conduct. It also includes sharing sexually inappropriate images, sending suggestive email and notes, telling lewd jokes, or asking questions about someone's sexual history. This form of harassment is any action or words that creates an uncomfortable environment for fellow employees. In this context, the word uncomfortable means that any reasonable person would believe that the working environment is uncomfortable. That is interpreted broadly because different people have different thresholds. In other words, the rule of thumb is no tolerance. Be especially careful about anything that can be considered as sexual stereotyping. Don't even say in jest something like, well, all you women are, or all you gays are. Well, that'll be interpreted as harassment. And as we'll discuss later, any type of stereotyping might get you into trouble. Now, when it comes to dating in the workplace, there is a rule of reason in place. Dating between coworkers may still be allowed, but there can be no harassment or intimidation of any kind. The relationship should be reported to management, and there is a no-contact policy while on duty. Also, there can be no suggestion of any favoritism. This is critical to understand. Now, bullying. Bullying is another form of harassment, including cyberbullying. Though often associated with grade school and the playground, bullying is actually a serious issue among adults as well. But it's not just childish jokes and mean remarks. Bullying is an escalating process that targets victims in a series of systematic acts intended to intimidate. Just like sexual harassment, bullying is uninvited, undeserved, unwarranted. It is often brushed aside as teasing or give and take, but claiming that a victim didn't seem to mind is not an excuse. Now, liability. It's important to understand that no one is immune in a legal sense when civil rights are violated. For a government employee, the lawsuit may be covered by insurance depending on the circumstances, but not all costs will be a part of that coverage. You may be personally liable for any punitive damages, and that's just the financial cost, the damage to your reputation, your career, your working relationships, incalculable. Now let's talk about prevention. Of course, the best defense against harassment and discrimination charges is prevention. Your employer has adopted a 5-part program to protect employees, volunteers, and the public. So the first step of this program includes a clear policy prohibiting discrimination, harassment, and a violation of civil rights. Second, a procedure for complaints has been instituted so that victims can communicate with the relevant authorities. And third, supervisory and non-supervisory personnel are trained to deal with harassment and its related issues. Fourth, the effectiveness of the program is consistently monitored. And finally, management has an unequivocal commitment to enforce these policies and communicate them clearly and often. Look, we need your help so that these policies are more than just words on paper. We all have a role in this anti-discrimination and anti-harassment program. For example, under no circumstances should you use jokes or nicknames or pick on anyone based on their race or religion or national origin or age or disability or gender or sexual orientation. It might be just teasing or give and take for you, but you never know when a line is crossed and the jokes become offensive. Their boundaries are being violated, not yours. And it's not your place to decide how much is too much. Saying, "I thought they didn't mind," won't stand up as a defense, and it's certainly no excuse for your own behavior. This goes for dealings both within your organization and with the general public. So in all your interactions, be proactive in preventing harassment. If you notice someone else pushing too far or turning things into the wrong direction, step in, warn them before the situation gets out of hand. When things go too far or you feel that you have been a victim of harassment, speak up. Racist, sexist, biased, or threatening remarks are never acceptable. You can talk to anyone in management about what you've experienced, not just your direct superior. The usual chain of command does not apply in these situations. Your rights are clearly laid out in the personnel handbook and the employee bulletin board, and you'll be protected from retaliation of any kind. Management has received training on how to address these situations. The policy is to take each accusation seriously and utilize proper procedures to protect the rights of everyone concerned. We also feel very strongly about the need for all of us to look out for the safety of our fellow employees and the public. Emergency services, public works, utility operations are inherently dangerous. It's sobering to realize that statistically, the typical local government worker has a higher chance of being injured on the job than a worker in construction or even an underground mine. Your employer has created a safety committee to provide the proper safety equipment as well as training. So if you see something that appears to be a safety issue, speak up. If you expect other people to look out for your safety, you need to look out for theirs. This is just as true when we're talking about issues that impact the safety of the public. Whistleblower protections. For this reason, the law protects whistleblowers from retaliation. A whistleblower can be anyone who in good faith files a complaint related to discrimination, safety issues, or any form of harassment. This can mean disclosing or threatening to disclose anything that the informant reasonably believes to be illegal, either as an initial complaint or as part of an investigation into violations. Whistleblower protection also applies to anyone who objects to or refuses to participate in an activity that they believe reasonably to be illegal or incompatible with public health and safety or welfare. So, to be considered a whistleblower, an individual must actually alert the proper authorities of the alleged wrongdoing. This caveat is why it's so important to regularly and clearly communicate the complaint procedure to everyone concerned. More information on specific procedures is in your employee handbook. Now, granted, there are situations where false claims arise. In these situations, if the person filing the claim knew the complaint was false, then they're liable to penalties for intentionally and knowingly filing a false complaint. This is an attempt to use harassment law to actually harass the accused, making it a civil rights violation with accompanying penalties and punishments. The whistleblower laws were enacted to protect individuals making complaints, but these only apply if the complaint was filed in good faith. So let me conclude by emphasizing that even if you personally are not the victim of discrimination or retaliation, but you're aware of something that is improper, you can and must speak up, even if the actual victim has not yet filed a complaint. In fact, that goes for all harassment situations or civil rights violations. You cannot ignore what you see in good conscience going on around you. When you know your rights and the rights of your coworkers, you can safely work to end workplace discrimination and improve the workplace for everyone. So we hope this conversation has been helpful for you in understanding your rights and responsibilities when it comes to harassment and discrimination. We can all do our part to prevent incidences in the workplace and make local government a safer environment for all. Thanks for watching.